Res sub judice and res judicata. Question: what do you understand by res sub judice and res judicata? When a suit pending before a court can be stayed? Answer: res sub judice. Res sub judice means to stay a new suit, the subject matter of which is already pending in court. The Latin word res means matter and sub judice means under trial. Therefore, the word res sub judice means matter under trial. Section 10 of the Code of Civil Procedure discusses with the doctrine of res sub judice. The question of stay of trial of a suit may be raised in any special case after the filing of the suit. Section 10 of the Code of Civil Procedure describes under what circumstances the trial of suit may be stayed. According to Section 10 of the Code of Civil Procedure, where the parties and the subject matter of a previously instituted suit and the party and the subject matter of a subsequently instituted suit are the same, the court may stay the subsequently instituted suit. However, if the previously instituted suit is filed before a foreign court, although the subject matter of that suit are the same, the later suit can be filed before Bangladeshi court without any bar. Example: A, the wife, files a suit for divorce and the custody of the minor child against the husband B. Later, B sues for the guardianship of the minor child. The later suit of B shall be stayed. Res judicata. The Latin word res means matter and judicata means already decided. So res judicata means matter already decided. Section 11 of the Code of Civil Procedure discusses with this doctrine if any suit already decided by a competent court and later another suit on the same subject matter and between the same parties is filed, the court shall not try the later suit. This principle is called res judicata. Therefore, suit already decided cannot be revived again. Therefore, where the trial has been once made, if again it is instituted, the doctrine of res judicata shall be applied. The court in Alam versus Salimullah Chaudhuri, 10 MLR AD 90, has decided that Section 11 of the Code of Civil Procedure bars to try a suit twice. Example: A sues for declaration of title B against B. Court gives judgment in favor of B. Now, if A again sues against B for the same cause, the court shall stay the suit, because the subject matter and the parties of both the suits are the same. In which situation a pending civil suit can be stayed? The following conditions are to be fulfilled to stay a suit under Section 10 of the Code of Civil Procedure. Number 1. Two suits. There shall two suits, one of which shall be previously instituted and the other shall be subsequently instituted. Number 2. Facts in issue. The subject matter of the previously and subsequently instituted suits shall be the same. Number 3. Same jurisdiction. The court in which the first suit has been filed shall have jurisdiction to give relief in the subsequent suit. Same parties. The parties of both the suits shall be the same. Number 5. Suit on same title. The parties sue on the same title. Number 6. Suit pending in a court. The previous suit is pending before a competent Bangladeshi or foreign court established by the government. If MD Bakr in MD Bakr Siddiq versus Tamijuddin Khan 27 BLD 57, it was held that if the above mentioned conditions are not fulfilled, the court shall not order to stay a suit under Section 10 of the Code of Civil Procedure. However, if the conditions are fulfilled, the court may order to stay the suit. In Ayat Ali Bhuiya versus Janata Bank 40 DLR 56, the court held that if the court fails to file a suit under Section 10 of the Code of Civil Procedure, it can order for a stay under Section 151 of the Code. If the above mentioned conditions are fulfilled, the civil court may stay the subsequent suit. Question: what is the difference between res judicata and admissions? Does an ex parte decree act as res judicata? Answer: the differences between res judicata and admission are: as to definition, where the suit have been conclusively determined by the court, and if later another suit is filed on the same subject matter and between the same parties, the court shall not try such suit. This doctrine is called res judicata. Admission means any statement which may be oral or documentary. Such oral or documentary statement provides presumption or idea on the matter in issue or relevant matter. As to Section 11 of the Code of Civil Procedure discusses on res judicata. On the other hand, Order 12 of the Code of Civil Procedure, Sections 17 to 23, 31 of the Evidence Act discusses admissions. Distinction as to application. Res judicata applies where the suit has been determined. On the other hand, where the suit is pending, admission applies. As to bar, a suit becomes barred by res judicata. No suit becomes barred by admission. Distinction as to object. Res judicata bars more than one suit on the same subject matter. On the contrary, admission helps to rapid disposal of the suit. Result: no new suit can be filed for the same subject matter because of res judicata. On the contrary, an admission acts as an estoppel. Question: does an ex parte decree act as a res judicata? According to Rule 6 of Order 9 of the Code of Civil Procedure, if the summons is served properly and if it is found that the plaintiff is absent, the court may give ex parte decree. Any subsequent suit after the ex parte decree order is considered as non-maintainable for res judicata principle. If any suit is decided ex parte, no new suit shall be filed on the same matter. Thus, an ex parte decree or order shall be regarded as barred for res judicata, because an ex parte decree shall have the same effect as if it would have been a bi parte decree. Thank you.